You spent good money on a living trust, right? You funded it, you signed every page, you did everything your attorney told you. And none of it matters if one beneficiary designation overrides your trust the moment you die. It is a single line on a form you filled out years ago, maybe at a job you might have already left. Here is what almost nobody realizes. That form you filled out, wins and controls, these accounts were never yours to give away in your trust. They pass by contract between you and your bank before a trust ever gets a vote. So the question is not whether your estate plan, your living trust is good, it is whether anyone ever checked the forms that you filled out in the banks. In this video, I'm going to show you the 3 account types where this happens most, the one federal rule that can send everything to the wrong person, and why a divorce may not fix what you think it fixed. Think about what a beneficiary designation actually is. When you opened that 401k or brought that life insurance policy or set up a payable on death instruction at the bank, you sign a contract. You told that bank in writing exactly who gets that money when you're gone. And that bank does not read your trust. It does not read your will or anything else you have. It reads that form that you filled out with them. And it pays to whoever is named on that form, often within weeks, long before a probate court or a successor trustee is ever involved. That's why I tell families the plan in your drawer and the money at the institution are 2 different worlds. And that form is the bridge between them. The form is not permanent, right? It can be updated at any time while you're alive. And in limited situations, a specific court order or a state statute can actually override what it says. The real danger is a form nobody ever goes back to check. Let me give you a real life example. I've changed the names, of course, and this is an example of situations I've seen, not just with one family, but with many. So for example, a father raises 2 kids, right? But later on, he remarries in life and builds a careful trust that splits everything equally between his kids. And then he passes away, and the trust does exactly what it says. It gives everything to the kids, but his largest single asset, which is his retirement account, worth more than the house, still lists his first spouse and named decade earlier and never updated. And the trust never touched it. The children never saw it. And the ex-wife collected all of that money, and it's legal too. Nobody committed fraud. The form at the bank, the beneficiary designation, outranked the living trust. Here's where precision matters, because 2 accounts that sound identical can follow completely different rules, and that difference decides who walks away with the money. Start with the account holding the most money for many families, the retirement account, right? An employer plan, a 401k, or a pension is governed by federal law. On most of these plans, your spouse is automatically the beneficiary, and you cannot name your children or anyone else unless your spouse signs a written waiver giving up that right. So a parent who quietly names the kids as beneficiaries may be holding a designation that actually doesn't hold up legally, because that spouse didn't give consent and never signed a form allowing the kids to be the beneficiaries. Now change one detail. Make it an IRA instead of a 401k. An IRA is not governed by those same federal plan rules. So the automatic spousal protection you just heard about does not apply the same way. That doesn't mean a spouse has no claim at all, right? California, for example, is a community property state, and money added to that IRA during the marriage can still carry community property rights a court will recognize. Same words in your head, right? Retirement account, but a completely different rule book underneath it. That is exactly where good families get hurt. And under all of it sits a trap almost everyone gets wrong. Many people believe a divorce automatically removes their former spouse from these accounts. On an employer-sponsored plan governed by federal law, a divorce by itself may not remove your ex at all. I see this happen a lot. Unless you file a new beneficiary form or the divorce produces a specific court order that addresses the account directly, the person named on that account decades old is the person who actually collects, not the person your divorce decree names. California does have a law that can automatically strip an ex-spouse from certain accounts after divorce. However, it does not reach every asset, and life insurance is specifically excluded from that protection. The form again outranks what you assumed unless you have checked it yourself. If retirement accounts are the most understood, life insurance is the most overlooked, precisely because it feels finished the day you buy it, right? That policy pays the named beneficiary directly outside your will, outside your trust. It's usually fast, which is wonderful when the form is right, but quietly devastating when it's not. A policy that still names an adult child who has since fallen into addiction, or let's say a lawsuit or a failing marriage, drops a lump sum straight into the middle of that storm with none of the protections a properly drafted trust would actually provide. For a parent whose whole goal is to protect a child, sometimes from that child's own worst season, that is the exact outcome the plan was built to prevent. But because the beneficiary wasn't the trust, now the trust can't provide that type of protection. The same logic runs through the accounts at your bank and brokerage accounts. A payable on death or transfer on death instruction turns any ordinary account into a beneficiary account. It passes outside of probate, outside the trust, straight to that named person. Families like these because they sound convenient, right? However, what they miss is that one of these instructions can quietly pull a large account out of the equalizing math the trust was supposed to do and hand it to a single child instead of all of them. And that is not a paperwork footnote, right? That is how brothers and sisters stop speaking to each other over what they each believe their parents really wanted. But there's a version of this that is worse than any sibling fight, and it deserves its own warning. If you have a child or a grandchild with special needs, naming that person directly on any of these beneficiary forms can actually jeopardize their SSI or Medicaid or Medi-Cal benefits that they depend on. That mistake is serious enough that it has to have its own video because the fix is specific and the stakes are a lifetime of care. For now, sit with this principle. The form does not know your intentions, it only knows the name. This is the part of the work most people never see. And honestly, it is what separates designing a thoughtful estate plan from just printing one out, right? Drafting a strong trust is the visible part. The quieter, more important part is sitting down with every account you own, the old employer plan, the IRA, the policy you forgot about, the bank account carrying a name from another decade, and confirming that each and every single designation on every single account actually points where your plan intends. When my team stands next to a family, we don't just stop at drafting the trust, right? We audit the forms because the forms are where a plan silently succeeds or silently fails. A thoughtful estate plan is not the paperwork in your drawer, right? It is the paperwork and the money finally telling the same story. Now that you know all of this, I want to encourage you to take action with a verse in the Bible. Proverbs 22:3 says, "The prudent sees the evil and hides himself, but the naive go on and are punished for it." So you just saw evil, right? You just saw how one outdated form can quietly undo an entire estate plan. So be prudent, be diligent, go home tonight, pull up every retirement account, every life insurance policy, every bank account you have, and check who is named on that beneficiary line. Make sure every single one of them lines up with your plan. Do not be the naive one who walks past this and gets punished for it. And while you're being diligent about your accounts and your assets, be even more diligent about your soul. Jeremiah 29:13 says, "And you will seek me and find me when you search for me with all your heart." God promises that when we seek him diligently with everything we have, we will find him. And John chapter 1 verse 13 tells us what happens when we do that. But as many as received him, to them he gives the right to become children of God, even to those who believe in his name. And that is the gospel. That's the good news. Jesus Christ, the Son of God, died on the cross for our sins and rose again from the dead. And anyone who receives him, meaning anyone who believes in his name, has their sins forgiven and is adopted as a child of God. That is the greatest inheritance any of us will ever receive. So if a single form can override your plan, it raises a bigger question. What is the real difference between a will and a trust? That is what the next video breaks down, and it is worth your time. At Tree of Life Law Firm, walking people through every account this way is a part of how we protect the family. So tell me, when did you last check who is named on your accounts? I would love to know.